Have you had a visa refused in Australia and now you've been told, Section 48 applies to you. You can't apply for another visa. But is that completely true? Not necessarily. Let me explain. Section 48 of the Migration Act generally applies. When you are in Australia, you do not hold a substantive visa, and since your last entry into Australia, you have had a visa refused other than a bridging visa, or your visa has been cancelled. If Section 48 applies, you cannot simply apply for any visa you want while you remain in Australia. However, there are certain prescribed visas that may still be available to you. For example, depending on your eligibility, you may still be able to apply for visas such as the Subclass 190E, 491, 494, or a partner visa. For a partner visa, however, there can be another important issue. If you do not hold a substantive visa, Schedule 3 requirements may apply. In some circumstances, you may need to demonstrate compelling reasons for the Schedule 3 criteria not to be applied. For example, circumstances explaining why the partner visa should be considered without requiring you to leave Australia. So, getting married to or being in a relationship with an Australian citizen or permanent resident does not automatically overcome all the requirements. Now, what if the visa you want is not one of the visas you can apply for onshore because of Section 48? There may still be another option. If you hold a bridging visa A, you may be able to obtain a bridging visa B and travel outside Australia. Once you are offshore, Section 48 itself does not prevent you from lodging a visa application. So, subject to the requirements of the particular visa, you may be able to lodge that application while you are offshore and then return to Australia on your valid bridging visa B. Depending on the visa and your circumstances, you may then be eligible for an appropriate bridging visa associated with that offshore application, allowing you to remain lawfully in Australia while the application is being processed. Sounds good? Yes, but there is a risk you need to understand. If your offshore visa application is refused, you may not have merits review rights at the ART. You may still be able to seek judicial review in the Federal Circuit and Family Court of Australia if there is a jurisdictional or other reviewable legal error. But judicial review is very different from an ART merits review. The court looks at legal error. It does not simply reconsider whether your visa should have been granted. So, if Section 48 applies to you, don't automatically think that you have no options. You may have an onshore option, a partner visa option, or potentially an offshore application strategy. But every option has different requirements and risks. So get proper advice before you travel or lodge another application. If you are affected by Section 48 and want to understand what options may be available to you, feel free to contact me.